Good afternoon and welcome to this SRA webinar to launch our Risk Outlook 2014. I'm Paul Woodcraft, a researcher within the SRA's Risk Centre, and I'm joined today by Tim Livesley, Chief Economist and Manager within the Risk Centre, and Laura Holloway, a Risk Analyst. The Risk Outlook plays an important role in clarifying why we regulate legal services. In particular, we want to ensure that consumers are properly protected and that the rule of law and proper administration of justice are secure. Through identifying and understanding risks and through your approach to mitigating them, we can assure that these issues are safeguarded. All three of us were involved in researching and putting together the content of the Risk Outlook, and we will be presenting a short summary of the document and hosting a question and answer session. The presentation that follows will last approximately 20 minutes, with the remaining time dedicated to answering your questions. If you would like to submit a question, please click on the Ask a Question button and type your question. Below the Ask a Question button, there are two further buttons, Overview and Resources. These enable you to download a PDF version of the presentation and to navigate straight to the exit survey should you wish. I will remind you of these points at the beginning of the question and answer session. The presentation will be divided into the following core elements. Firstly, we will talk through the structure of the Outlook, which has changed slightly since the 2013 release. This will be followed by an outline of the drivers of risk, the current and emerging risks identified, and how managing these risks can bring about benefits to your business. In addition, we will provide you with a brief overview of our forthcoming risk publications. Before we begin, just a quick note that we'll be using the term firms to describe entities delivering legal services, whether they are individuals in sole practice or larger firms, and whether they are solicitor-only firms, alternative business structures, or in-house providers. The Risk Outlook and the information contained within it is derived from a variety of sources. Internal sources include SRA data, case file reviews, frontline staff experience, and solicitors' disciplinary tribunal cases. However, significant emphasis is placed on securing inputs and viewpoints from external sources. This is achieved via events and consultations with firms to obtain a professional perspective on the risks firms are seeing on the ground, and analysis of academic literature, published statistics, and media coverage. If you would be interested in taking part in a roundtable consultation on risk, please use the question box to message us with your name and email address, and we'll get in touch about attending the event. The Risk Outlook for 2014 has been organised into two constituent parts. Part A identifies and explains the drivers of risk and has been divided according to economic trends, market and firm level drivers, political and regulatory changes, and consumers. Part B sets out our key risks to the regulatory objectives. These have been grouped into two categories. Current priority risks, where we have evidence that these risks are widespread, current, and pose a significant risk to the public interest, and other priority risks, which are still priority risks but are not widespread in the legal services sector, or there are evidence gaps, which means that we cannot be as certain about the full extent of these risks. I will now hand over to Tim, who will talk through the drivers.
Hi, I'm Tim Livesley. I manage the Risk Analysis Research team at the SRA, and just going to talk you through the four sections of drivers of risk that we've set out in the Outlook. The first one deals with economic trends. It was really interesting when we started putting together the 2014 Risk Outlook that this jumped out as one of the biggest differences in perspective from when we were putting together the one in 2013, when everyone was very gloomy about the outlook for the UK and global economy. When we were drafting this version, trends were looking far more positive. Growth was running at a rate of over 3% more than a year ago, and generally lots of other indicators were looking a lot more healthy. This means that we can't take our eye off the ball with risks which are driven by market pressures. Certainly we're seeing different pressures in different sectors of the legal market. The conveyancing market, for example, has certainly gone from strength to strength in the last year, and there's even concerns about it overheating. One of the key things is where it links back to the activities we see in law firms, is that where firms are gearing up to deal with this increased level of activity, the increased market opportunities, it's really important that care is taken to make sure that capacity isn't overstretched, that people who are recruited are done so with the right skills, and essentially there is no knock-on adverse effect on the goods, the services which consumers receive. We also picked up on a number of other ongoing trends. Interest rates have been at historically low levels. It's likely that they're going to start increasing. That will have an impact on firms' borrowing and also the interest held in accounts. And we're also seeing this increased trend of law as a global business, which provides huge opportunities for the UK economy. But it's also very important now that we're seeing it not just the preserve of the big business, the big law firms, it's also something which much greater numbers of law firms are actually able to take advantage of. It's really done so, it's really important as firms move into new jurisdictions, it's done so with an awareness of the risks that are associated with these new areas. Then moving on to market and firm level drivers of risk. Those of you who are familiar with the 2013 risk outlook will have noticed that one of the most significant changes is that whereas we put financial difficulty as a key current risk in 2013, we've now moved that as a driver of risk in this version of the outlook. And that really reflects all of our learning and experience of managing this risk over the last 12 months. We published research last year which showed that we see a much greater association of risks such as misuse of client money, money laundering, poor standards of service in firms that are in financial difficulty. And that's why we have been looking at this as a key issue in the market and something where it's relevant for regulators to focus some of its attention. We see practices in firms such as excessive borrowing and debt, inappropriate use of client account, which all had knock-on effects to risk which actually affect consumers. So it's an issue which we're not saying is no longer an issue because it's not in one of our current risk sections. We're just positioning it as something which we see as driving a lot of the issues that we see. And if you do get a chance to take a look at our risk index, which we published in March, that sets out a lot more of our thinking about how these risks interrelate and how we go about approaching them. Other changes at firm level, we're seeing the market consolidating more. I'm sure that's an issue that lots of firms will be aware of. I always think that if people sort of fast forward 10 years from now, look back at the legal services market and comment on the biggest changes, one of those biggest changes will be the consolidation. Bigger firms becoming more dominant, smaller firms becoming more niche in order to survive and prosper. It could bring with it many benefits. It's possible the consolidated market might produce positive outcomes in terms of access for justice for clients. But with a changing market also comes risks, and it's important that firms are aware that they're operating in a changing environment. As firms get bigger, there's also more risk of group contagion as firms form conglomerate structures, and it's important that appropriate firewalls are put in place when firms enter in those kind of arrangements. Another big issue in the market that we're aware of is weaknesses in exit planning. That's something that we keep our eye on at the moment, and it's something that you'll see that we're consulting at the moment about things like run-off cover to try and make it easier for firms to exit the market. With an ageing solicitor population, with some sectors of the legal market going through major restructuring, it's important that we're not just aware of the barriers to entry to the market, but also barriers that might keep firms in the market that are trying to exit.
You'll see today actually just like a hot off the press item on that. We announced today that the first fines had been given for people who had failed to instigate an orderly wind down within their business in time, having been put in the EPP of the professional indemnity, but they failed to secure that. So we are taking regulatory action against those who fail to secure the orderly wind down and exit of their firms.
And then just quickly to finalise on the firm level drivers, we're seeing an increased variety of firm structure. That's really interesting because we're keen that we do see more diversity in the types of structures providing legal services. And we're currently consulting on ways that we can do that through things like multidisciplinary partnerships. And then finally, fixed fees, we're seeing that as an increased feature of the market and an area where firms are having to think through exactly how they go about making that stack up within their business model. Then the drivers of change are also linked to political and regulatory changes. I'm sure everyone on the webinar will be very aware of the significant changes going on in legal aid funding. We're keen that we monitor that to make sure that standards are upheld and that access to justice isn't compromised while that process works through, and it's a market which is in a significant amount of flux. We're also making sure that our teams that deal with the authorisation of new entities are also geared up to be able to turn around requests for new business structures in a very timely way to help those firms actually deal with those market changes. The personal injury market is another area where there is huge changes going on. We've had a year of the referral fee ban bedding in, and we're also looking at how we will respond to the potential ban on inducements, which the government is currently looking at. The one thing we can say with certainty is that if that is passed, we will obviously make sure that the law is upheld, but we'll obviously need to let the dust settle on that so we can actually see how that change actually pans out and what the actual ban itself looks like if indeed that does go through. But one thing on the personal injury market, it is an area where there is rapid change, and I think it's also worth bearing in mind that where you do see significant levels of change, that it's important that the people working in that market are aware of that. Other big changes, tax changes affecting firms, rulings by the way the courts operate are affecting firms. So it's important that those changes, we're aware of them and they're communicated to firms. And then the other thing to note here is that there's also been a significant change in our communications about how we'll regulate in the future. We're looking at ways to reduce the burdens on firms to make sure that firms are able to comply in a more cost-effective way. And then our fourth and final area where we're talking about drivers of change in the risk outlook is about consumers' behaviour and expectations. One of the key issues here is about access to legal services. There is a significant amount of unmet need for legal services, and when we are worried about an access to justice issue in the market, firms should also see that as a potential opportunity in terms of an untapped demand for legal services, which is out there. So this is an area where our interests and firm interests are very much aligned. Research has shown that 1 in 3 consumers that face a legal problem don't actually follow that through with any form of advice. So there's a huge number of people out there that aren't getting professional support, and also research has shown that small businesses also have a significant amount of untapped potential need for legal advice. So there's market opportunities there, but it's an area where we worry about access to legal services. And then finally, consumer vulnerability, which is a feature of our approach which comes through throughout this risk outlook. In the forward, we talk about how it's important that our regulatory protections match up with effectively the ability of consumers to look after their own interests when they use legal services. When we talk about vulnerability, when we're thinking about characteristics of the consumers which might undermine their ability to look after their own interests. So it could be things like consumers that are less able to understand the system that they're operating within, or are less able to get access to redress. We're currently doing some research at the moment on the experience of asylum seekers when they use legal services. They may be a group where access to redress could be particularly limited. And we're also think about the potential impact when things go wrong on consumers as being another indicator of potential vulnerability. So I'm now going to hand over to Laura Holloway, who's going to talk you through some of the key current risks in the risk outlook.
Okay, so I'm Laura and I'm a risk analyst within the Risk Centre, and what I'm going to talk to you about is not only our current priority risks, but also, as it says in the title, how managing these risks can benefit your business as well as helping you to meet your regulatory obligations. So if you're looking at this slide, you're probably not that surprised as to a number of things that are on there: misuse of money and assets, money laundering, bogus firms, etc. But we're just going to give you a few facts about them and also just talk about how it could be beneficial to your business to manage them. So the first one is the misuse of money and assets. And as it says in the Outlook, around 30% of our interventions actually involve suspected dishonesty, and around half involve suspected account rules breaches. So this is something that we take very seriously and can lead to intervention if we do find evidence of this type of behaviour. In the driver section, Tim mentioned financial difficulty, which can often be a catalyst for misuse if the temptation is there to dip into the client account to fund the firm with the intention of paying the money back. I mean, it's something we've seen over the last few years, and it is something we expect to see again. And I was actually reading an article in the Solicitor's Journal recently, which I thought gave a great message around this, which was that having financial problems is not misconduct, whereas lack of integrity is misconduct. So taking financial advice and discussing any issues with the SRA is not in and of itself going to lead to us taking disciplinary action against the firm. What will is if client or office money is misused to try and mitigate financial problems. So there may be people that are in very difficult situations and are thinking, well, I don't want to contact the SRA because I'm afraid that something bad will happen. So instead, I'll borrow some money from client account or office account and use that instead, when actually the reverse would probably be less likely to lead to regulatory action than the former. In terms of how firms can manage this risk, I think the key is just to have good systems and controls to protect your client's money. It's not rocket science. There's not, basically you just need to have those controls and those systems there, being clear about who can access the client account. And obviously remember to report to the SRA if you're aware of anything suspicious at your firm or another firm with regards to the misuse of money and assets. The second risk that I'm going to cover is money laundering, and you may have seen from press releases this week that this is an absolutely huge focus for the SRA over the next few years. We do expect to be publishing a paper on it before the end of the year outlining the risk and controls of money laundering. So the National Crime Agency actually singled out lawyers as the source of poor quality suspicious activity reports, and they did write to us regarding this. Many of these reports did not contain enough information for the NCA to make a decision about whether a transaction should go ahead. So obviously there's only so much detail you're able to give, but not including things like the property that you feel may be being laundered, not including things like the details of who it was that was trying to launder it and what type of transaction it was, makes it very difficult for the National Crime Agency to make any sort of decision about whether that is suspicious. So we'll be working on that. The report that we're going to put out will contain further guidance on how and when to make an effective suspicious activity report alongside case studies and self-assessment questions. So hopefully that will be of use in terms of updating firms at just what a good suspicious activity report would look like and perhaps why there's been some problems with the quality. I mean, in terms of how it can benefit your business, obviously being associated with money laundering is never a good thing, but the best protection against someone attempting to launder money through your firm is actually keeping up to date. So whether that's through money laundering training or through just being aware of what type of money laundering is going on at the moment, what it might look like, but also carrying out appropriate checks such as identity verification and the source of funds. Attempted money laundering, I mean, it is the sort of thing that could happen to any firm. Somebody looking to launder money isn't going to think, oh, this firm always has nice clients, therefore I'm not going to go there. It could potentially happen to any firm. But you are actually more likely to be targeted if criminals believe your checks and controls are lax. So if they've been able to do it once and they know that you're not checking ID adequately, they're likely to come again. So I suppose it's also a great selling point for a firm to show that your controls are strong and that things like money laundering and criminal association aren't something that would happen. Then we have bogus firms. There's been a lot of media coverage over bogus firms since the Outlook came out in July, particularly in relation to the accusations levelled at payday lenders that they had invented fictitious law firms to chase debts. There were then subsequent revelations about in-house law firms giving clients the impression that their debt had been passed to an external firm. We've provided guidance on this on the SRA website, and this comes against the background of us receiving increasing numbers of bogus firm reports. We've had over 200 just in the first 4 months of 2014 alone, and this frequency of reporting has continued since the Outlook was published. A key trend is the use of the details of legitimate law firms, and this is kind of where you come in, where managing risk being good for business comes in, is that although you can't prevent criminals trying to set up bogus firms, and neither to much extent can we, however, there are things that you can do to protect your own identity and uphold your reputation so it doesn't become associated with bogus firms. Even things as simple as regularly searching online for your firm just to check if there are any cloned websites out there can be a good way to identify if you've been subject to identity theft. We also have scam alerts on our website and on our Twitter, and they can keep you up to date with current bogus firms or bogus emails. If you are a firm that regularly does transactions where there's another firm on the other side, this may be particularly relevant in terms of just making sure that those who you have business with aren't bogus. We also have here lack of diverse and representative profession, and this is quite different to the other risks in the current category in that it's at market level rather than we're not necessarily talking about it at individual firm level. A diverse profession ensures that law firms have the best talent available, so it's obviously of benefit to firms themselves. And it's also worth pointing out why the SRA has this as a particular priority compared to perhaps other regulators, is that because we're dealing with the criminal justice system and the rule of law and upholding that justice system, it is important that those who provide these services are reflective of the society that we're in. We're not saying, you know, there has to be one black lawyer for every black person, but we're just saying it needs to be reflective of society, and it's also just putting the onus on the profession to be attractive to those who wish to take up legal services. As Tim mentioned earlier, there is a lot of untapped legal need out there, and perhaps if people are seeing that solicitors working in firms don't reflect them and there's nobody with their background working as a solicitor, that may mean that they're not actually seeking out legal help. So I think it's really of benefit to firms to just have a look at yourselves and think, you know, am I doing my best to attract people from different types of background? And we've just got a few stats for you about the current diversity of the profession. The difference in pay between men and women is in the general population is around 10% overall, whereas in law firms it's 30%. So to me that was quite a stark contrast and just shows how, although the profession is becoming more diverse in terms of people coming through the door, are these people progressing through? And this isn't just because there are more men at partner level. Women are on average paid less at every level. A third of partners or equivalents of partners attended a fee-paying or independent school. This is obviously very disproportionately high in the general population. Only about 7% of people attend fee-paying schools. So it's this type of figure which made me think that although, you know, we're always promoting diversity, these figures really say to you, you know, this is the stark reality of it. We're not reflective of the general population, and we do need to do more to attract the best range of talent. And the Law Society recently published a business case for diversity, and it's actually been really positive for us to see many law firms across the country advertising diversity as a selling point for their firms. And firms that we've spoken to have also said that there's clients who value the fact that they uphold diversity as a value and are actually requesting to see equality and diversity policies. And finally, we're talking about poor standards of service, especially to vulnerable consumers. It's obviously a key risk for us that some of the most vulnerable people in society could be prevented from accessing justice due to poor service. An example of this that we're currently looking at is the quality of advice in asylum cases, as there is evidence that some asylum seekers are not receiving adequate advice and consequently may be victims of injustice. Anyone has the potential to be vulnerable due to the difference in knowledge between the provider and the client. So in terms of it being good for business, obviously if people feel vulnerable when working with you, anything you can do to make them feel comfortable and explain things to them in a clear way is always beneficial. So I'm now going to pass you back to Tim, who's just going to talk us through the other priority risks.
There are three other priority risks that we wanted to highlight. The first is about breach of confidentiality. And this is something which has always been an issue for people working in legal services. It's a core duty to keep the affairs of clients confidential. One thing that we have noticed is that some of the recent breaches which have been reported to the Office for the Information Commissioner and been received some fairly significant fines have actually related to firms which have been using fairly antiquated and ineffective paper-based filing systems. It's an encouraging sign that we're seeing more and more firms using more advanced systems of managing their files and moving them onto IT-based platforms. But with that also comes risks which need to be managed, mainly in the form of the potential risk of cybercrime. We published a paper on this back in March when we did our spring Outlook update. There's a detailed paper there which talks through various case studies which demonstrates the different kinds of forms that cybercrime can take. One thing we noticed when pulling together the 2014 risk outlook was that one of the examples that we highlighted there, which hadn't actually affected any law firms at the time, was an issue called CryptoLocker, which is a virus which is used to infect law firms' IT systems and effectively takes their data hostage and requires people to pay for the information to be then released back to them. And if they don't do that within a certain period of time, it gets permanently deleted. When we put out the spring update, that kind of example hadn't actually affected any law firms yet. But by the time we got to the summer and the Risk Outlook 2014, there was actually an example of this affecting a law firm in the USA. And because they didn't act swiftly, the criminals behind that scam actually deleted a significant amount of their client data, which led to them to get into difficulties with both their regulator and obviously the clients of that firm. So these risks do become very real, and things which on the face value can sometimes look like almost science fiction do actually come to pass as real threats. So it's not one to put law firms off from opportunities which actually reduce real risks associated with paper-based systems, which are sometimes potentially greater risks. But in doing so, it's important the flip side and things like cybercrime are also properly taken care of. The second risk to talk about is down to a lack of independence in the delivery of legal services. One of the things to reiterate is that it's very important that lawyers' duty to the court and society go beyond the maximisation of profit and the interests of their own clients. So it's the principles to do with the administration of justice which have to take precedence over principles to do with good care of clients when those principles come into conflict. It's an issue that we've seen particularly in law firms where there are particularly dominant clients. So firms or departments within firms that just have one or two clients, which make up a very large proportion of their revenue, perhaps being pressured or succumbing to pressure to get involved in practices which aren't entirely ethical. Examples of this have included firms being pressured to use their client's account as a provider of personal banking facility to clients, or to take forward cases which would be viewed as, or have been viewed as frivolous by the courts, but have been taken forward due to client pressure rather than a sensible legal judgment about what is a sensible case to take forward. So it's an issue that we're investigating in more detail through research to make sure that we can understand exactly how this risk manifests itself in firms and the best approach that we can take to support good firms to avoid this risk from materialising. And then the final risk included in the 2014 Risk Outlook is to do with improper or abusive litigation. And here again it is about manipulation of the criminal justice system to deliver often usual financial benefits for a firm or its clients rather than prioritising the proper administration of justice as the first and most important principle. Examples that we've seen include judges criticising law firms for aggressive correspondence in litigation or unethical conduct towards witnesses or their statements. And judges have also highlighted the issue of a serious or concerning amount of frivolous litigation being brought forward, which is effectively wasting the court's time and not advancing the public interest or the proper administration of justice. So these are issues that we need to explore in more detail, but we are seeing a real number of cases where we're quite concerned by the ethical conduct of law firms in litigation. And then finally, we're also seeing a significant number of cases where judges are dramatically reducing the cost claims in litigation cases when the cases are dropped, sometimes by over 90%, which makes it very clear that these inflated costs aren't just down to a difference of opinion about how the bill should be formed, but they do seem to indicate some misconduct in the conduct of the solicitors putting them forward. So there's a number of issues to do with abuse of the litigation system, and that's one thing that we're keen to keep a close watch on. So that concludes the summary of the key risk of it in the Outlook, and Laura's just going to talk you through some of the next steps for us in terms of information we'll be publishing soon.
Yep, we'll come on to your questions shortly. But just to sum up what the Risk Centre and the SRA have got coming up in the next few months, we're planning to publish an autumn update of the Risk Outlook. That will be in November, and so that will give an update on the risks that are in the Outlook and what changed, and will contain new evidence. Then I've put underneath 3 papers that we're currently working on, one which is on money laundering, one on getting value from diversity data, and one on bogus firms. These are going to come out before the end of the year, and they'll hopefully give you a little bit more information about these risks, a bit more in-depth, and also just some guidance around self-assessment and things like that. So the money laundering one obviously coinciding with our increased focus on money laundering and the launch of our programme of visits on money laundering. The diversity data, obviously, I mentioned before how much of a priority this is for the SRA. And then finally, bogus firms, just giving you a bit more information. But I think the thing that ties these papers together is a bit like the ties for the fifth, managing risk is good for business, in that not just showing what the risks are, but actually what firms can do and how that can benefit them. And then finally, I've put at the bottom risk roundtables. As we mentioned earlier in the section about evidence, we do actually feel it's really important to consult with the profession in terms of content for our risk outlook and get opinions about what you're seeing on the ground and what the SRA needs to know in terms of managing those risks. So if you are at all interested in participating in these events that we would have sort of at various places around the country, then please do send us a message through the Ask a Question button and we'll get back to you about that.
Okay, so that concludes our presentation. Thank you very much for listening, and we hope you found it informative. The presentation has outlined our current key risks and the benefits of managing them. If you would like to read the full risk outlook, any associated publications, or the reports coming soon that Laura's mentioned, please go to our website www.sra.org.uk/risk or contact us on risk@sra.org.uk.
Thank you, Paul.
So we've now put some time aside to take your questions. If you'd like to participate in the question and answer session, please submit your questions using the text box on your screen. And we've had the first question from Brian. He said it was recently said that the SRA was looking at whether the COFA regime should remain in place for small firms. Would this mean small firms not having to report breaches, maintain risk registers and comply with other aspects that COFAs in larger firms will have to?
It's probably too early for us to be able to answer the specifics of that question. It will remain within Principle 8 that firms will be expected to manage their firms in accordance with sound financial and risk management principles. So I would expect that firms would continue to want to maintain things like risk registers regardless of the regime that the SRA plays around that, because that would just make good business sense to have that kind of practice within any firm or organisation. I think what Paul Philip was talking about there in particular was that we do need to take a close look at our regime, the kind of costs that places on all different types of firms, and say where you have sole practitioners, is it really necessary for us to expect them to go through a process of nominating COLPs and COFAs, re-updating any processes there in the future? Does it really add any value for us or them? So I think there's some sensible questions for us to look at there, but in terms of specifics, I would expect that it's too early to say exactly how any changes would come about, but I would be very surprised if firms did want to drop very important risk management tools like risk registers, which just make a lot of sense to have in place, regardless of what we require of a firm.
Yeah, Tim, I think it's worth also saying that in terms of consultation with those outside the SRA, we are committed to consulting on policy changes, and so it is likely that if there are going to be any changes to the COFA nomination regime, that this would be consulted on the SRA website, and we would be open to comments from those outside the SRA on this. So if you do have a particular view, do please watch out for those, and our consultations are available on the SRA website.
Okay, we've had a couple of questions regarding compliance. The first one, will our money laundering visits to firms look at other areas of compliance if concerns are identified?
So I'm happy to answer this one. For those of you who haven't been aware of because the press release only went out this week, what Paul's talking about there is visits that we're taking to various firms to look at whether their systems and controls around preventing money laundering are robust enough. So these visits will be targeted specifically at money laundering. So they'll be going and asking questions relating to money laundering, discussing what systems are available, reviewing documents, etc., that relate to money laundering. Obviously, at the end of the day, we are a regulator. If during this process we found, evidence of misuse of client money, even if it didn't relate to money laundering, obviously we are going to take notice of that. However, these visits are targeted specifically at money laundering. They're not a full firm audit. They are audit relating specifically to money laundering. So I hope that answers your question, but obviously as a regulator we can never commit to, we won't look at something else if it emerged from the documents, but they're not full, they're not looking at everything, they are looking specifically at money laundering.
Okay, and another question around compliance. Will there be more guidance produced on overseas compliance and risk in conjunction with the International Division of the Law Society?
Well, at the moment, I was talking earlier about how we're seeing globalisation as a much more of an increased trend across all different tiers of firms in the legal sector. At the moment, I think we've set out our approach to how we regulate global practice of law in a fairly sensible way and a straightforward way. And the main principle underlying that is that when a firm is operating in a different jurisdiction, it is the regulations of that jurisdiction which take precedence. And we will only really focus in on the 10 high-level principles and apply those to firms that we regulate. Other than that, it's the local regulations which take precedence. So we're not adding anything over and above that, other than we will make sure that firms are complying with the 10 professional principles, which looking after the interests of your client, protecting client money. I don't think any decent law firm would want to drop those principles regardless. So at the moment, I'm not personally aware of any further reviews that are underway, but it is an area of law which is constantly changing. It's an area where we need to remain flexible and nimble because as markets change, there's no point regulation remaining static. But I think the approach that we've already set out is very pragmatic and shouldn't add too much additional burdens in the way of law firms that manage their activities across international borders effectively.
Thank you, Tim.
Okay, in relation to misuse of money, Laura mentioned misuse of office money. What sort of scenarios are envisaged for this?
Okay, so this has come up from Praffle, and I am happy to answer that one. When we're talking about misuse of money, we did used to, in our previous risk outlook, talk about misuse of client money, non-client money, but we're now starting to think that misuse of money is a serious issue wherever it takes place. In terms of misuse of office money, I think that we're talking about, for example, individuals within a firm who might seek to steal from the firm, or money that's been allocated to certain things being moved to pay for something else without the authorisation of senior partners. So it's essentially, I think most people can get a general idea of what misuse might mean. And we've also seen issues around expenses fraud and things like that, and we're aware that although expenses are likely to be paid out of office accounts, these may be charged to clients, and that type of fraud can have impact in those ways. So I think it's just, there's a broad range of scenarios, but it is, when we think of office account misuse, obviously the initial thing would be an individual who was stealing from the firm. Paul, do you want to move on to our next question?
Yeah, just a very quick one on money laundering in terms of when the paper will be published, in which month?
We're saying before the end of the year, just purely because we want to balance us gathering data and providing the most comprehensive report possible and getting it out in a timely way. So we're not going to give a date at this current time just because we want to make sure that we've included everything that's going to be useful. However, it will be before the end of the year. That doesn't mean the 31st of December.
And also likely to be in line with the autumn update of the risk outlook.
Yeah, I think that's the plan. I think obviously everyone's probably aware there's a lot going on around money laundering at the SRA, so we just want to make sure we're including all that. But yes, it should be around November when the autumn update comes out.
Okay, I've had a question from Jacqueline, who wants to know, I'm seeing a greater increase in clients complaining about cost levels, even when they're happy with the service provided. It's very difficult to get this right, as clients are told about their rights to complain, and they do so simply to get bills reduced and pay less. How can firms manage against this risk?
Okay, so it's worth us saying that in terms of client complaints, we are, in the risk outlook, we're presenting risk to our regulatory objectives rather than risk specific to firms, and we would expect firms to deal with complaints in line with what's in the handbook, and I know that the Law Society provides a lot of information about appropriate dealing with complaints, but it can often be a very sensitive issue in terms of what the firm might feel was reasonable, what the client might feel was reasonable, but it's something where our view in terms of vulnerable clients and poor standard of service would just be that you need to engage with the client and take a complaint seriously, regardless of what you feel the merit of it is at the time. Once you've investigated it, as long as you've done it in the right way, if they choose to take it further and go to the legal ombudsman, then if you've dealt with it in the right way and provided a good service to your clients, you should be able to demonstrate that you've done that.
Yeah, it sounds like communication is key here. It's clearly a big challenge. It's something we hear from lots of firms. One of the key regulatory responsibilities is making sure that you're clear with your client up front about how the fees are going to be calculated. And if firms are doing that, you should be in a pretty strong position to handle that complaint. I think from there on, it then becomes a business-to-client relationship where you just have to deal with that as businesses do in other sectors, making sure that you resolve that in a way which works for both the firm and the client. And then there is the next tier. If you can't resolve it at the first tier, then obviously Leo are there to provide additional support.
Mm-hmm.
Okay, but a question pertaining to COBs and COFRs. Has the SRA been made aware of any cases where COBs or COFRs have had conflicts with their partners over reporting?
I'm not aware of any specific examples being brought to my attention. It sounds like it's a scenario that I've often heard people talking about as a potential concern and suggesting what would they do in that situation if it arose. But it's not one where I've ever had any specifics being brought to our attention. The COB or COFR should be of sufficient seniority within the business to be able to make a sensible decision about whether it should be reported to us, and it's then up to them to discharge that duty accordingly.
Thank you.
Okay, another question relating to money laundering. What does the SRA consider to be a high-risk firm for the purpose of money laundering? Is it the same as high risk leading to relationship management or another metric? Okay,
this is a question from Sarah, and I'm happy to answer this one. In terms of the visits that we're doing on money laundering, what we meant by using high risk in the press release is that we're not going to be visiting firms that there's just no risk of money laundering at all. Obviously, there are certain areas of work which mean that you may be more likely to be involved in money laundering. And yes, there is an element of the high risk in terms of relationship management. But those firms who are in relationship management, regulatory management, and who are considered high risk just purely because of their size and the amount of client money that they hold and the amount of clients that they have, will already have spoken to their regulatory manager extensively about the risk of money laundering and may well be aware already of the likelihood of these visits. So we're not saying that we're going to knock on the door and you're going to answer it and we're going to say, hi, we're here for a money laundering visit. It is very strategic and it is looking at, well, what are the type of things that make firms high risk of money laundering? There's no specific metric in terms of what we see as a high risk money laundering firm. So I hope that answers your question.
Okay, I have a question from Jeanette. In terms of the diversification of the legal market and the way in which legal services are provided, together with improving promoting access to justice, please can you confirm when the SRA will consult on the current separate business outcomes? which are arguably one of the largest barriers to diversity in the delivery of legal services?
We can't answer the question of when. I don't think any date has been set for that. At the moment, our board will be considering our proposals around changes to how we regulate multidisciplinary practices. I think Paul Phillips spoken about that recently in interviews with the press. So we are looking very closely at how we remove restrictions that prevent diversity of the different structures that are able to practice law. I suspect that further down the line we are going to have to tackle this issue around the separate business rule. It's been one which has been subject of enormous debate, particularly amongst ourselves and the Legal Services Board. So I'm sure that that is going to be the focus of further consultation, much more debate. But in terms of the question about when that's going to take place, I'm not aware of any date that has yet been set for that.
Thank you, Tim.
Okay, and we've got a question from Des. You mentioned Law Society guidance, I'm assuming in relation to cloud computing, but have you seen any specific issues with firms using cloud services, e.g. Google Apps, for storing emails and documents electronically as a paperless office?
I can answer this one. I think our attitude towards firms using cloud services is the same as whatever method of information storage firms decided to use. It's about the controls that you have, and it's about, are you protecting against breach of confidentiality? So whether that you're storing items on the cloud or whether you're storing them in filing cabinets, the issue is still the same in terms of we would expect you to take reasonable steps to protect that information from unauthorised access. So just as somebody could be overheard on the train discussing a case, if you're storing something on an app and allowing people to have that app on their personal phones, go home, look at it, obviously it's going to be less secure than if it's something that you have solely within your firm on encrypted devices. So what I would say is, no, there aren't specific cases that I can call to mind. However, there's certainly guidance in our cloud computing paper that we've published that's on the RISK website, SRA/RISK. And it provides a lot of guidance in terms of how you can protect if you do decide to use cloud computing, because we do recognise there are a lot of benefits to this and it can actually be helpful in mitigating risk. So I hope that answers your question, Des.
Yeah, and just to add to that, the Law Society published their own guidance on this, which is very useful. If you go to the risk resources page of our website, you'll find our own paper on cloud computing, as well as the cybercrime paper, which we've already commented on. Just one other thing, just to comment on the whole, how to manage this risk within a law firm of any size. It's often assumed, I think, that cybercrime protections are going to be complicated, something which you need, a sophisticated IT manager or specialist to do. But in actual fact, it's the things which actually lead to the most breaches, the most problems, are actually the real common sense things, like not having passwords which are easily guessable, not putting information on memory sticks which can be easily lost, and not putting them on memory sticks which aren't properly encrypted.
So the classic one would be like emailing stuff home on a non-encrypted email.
That's a really good example, and that kind of thing gets firms into difficulties and really opens the door for, sometimes you can't help but fall victim to a very sophisticated cyber criminal, but what you can do is prevent 99% of attacks by just doing the real common sense measures. So it really doesn't have to be a cost-effective thing. A cost-intensive thing, but it can be a very cost-effective thing just to do the basics right.
Mm.
So I think, is that all of the questions that we've had so far?
Yeah. Is there anything that either of you want to add?
I think the only thing that I was add, just because we had a few questions about the money laundering visits, and obviously probably what you've seen so far is a press release, and so the questions will be, well, what are these visits about? What are they going to do? If you are going to be involved in these visits, you will be contacted by the SRA and those on that team to give you much more detail. You won't need to you won't have half a day to respond to things. You will be contacted, and so hopefully the questions that you have around that will be answered by the team involved. So apologies if I didn't make that clear, but any further questions you have on money laundering, then hopefully that will be answered by the team involved. But if you do have any particular burning issues, then do feel free to contact the SRA.
Right, well, thank you very much for your time today. I hope that's been useful, and thank you very much for all of your questions.
And if you're interested in providing us with feedback on the webinar, as we will use it to improve future presentations, please click through to the feedback survey by clicking on the documents links and selecting survey link. Thank you very much.
Thank you.
Thanks.